I was served with divorce papers in Naples, Collier County, Florida. What do I do? Getting served with divorce papers is a dramatic event. Whether you knew you were going to get divorced or not, getting served divorce papers is not the most delicate of situations. If you were served with divorce papers in Naples, Florida, you'll need to know a few things. Part of the divorce papers that are served are actually called a summons. A summons is a document that starts every lawsuit and alerts the defendant/respondent that there is a case against them. Attached to the summons should be the actual petition for dissolution of marriage that outlines a summary of what the petitioner believes are the facts in the case and what the petitioner is asking the court to do based on those facts. All Florida divorce cases use the same summons form. That harsh language is there to get your attention, so you should really pay attention because the dates on the form are very important. The instructions don't tell you what should be in the written response because that all depends on what was in the petition for dissolution of marriage, which is attached to the summons. The most useful local attorney referral service is the Collier County Bar Association's Lawyer Referral Program. For $50, you can get a 30-minute consultation with an experienced local family law attorney. Upon hiring an attorney, the attorney will then prepare a written answer to the petition for dissolution of marriage and file their appearance in the matter so the opposing party and their attorney know to direct all future correspondence to the attorney. If you don't file a written response, the opposing party can file a motion for default after 20 days asking that you be held by the court to be in default and that the court subsequently enter a final order entering all of the items requested for in the petition for dissolution of marriage. Avoiding service is almost never advisable. Without service and a written answer on your behalf, your spouse can use the Collier County court system while you cannot. If you know or suspect your spouse has filed for divorce in Collier County, Florida, but you don't want to be embarrassed by a process server approaching you at your home or work, you have a few options. Just look up your case at the Collier County Courthouse and file an appearance. A more roundabout way to avoid service is to request from your spouse or spouse's attorney a waiver of service. After service, you're now under the power of the judge's standing order. There is one standing order for litigants with children and one standing order for litigants without children. So, if your spouse has filed for divorce in Collier County, Florida, you have to make arrangements for the children's schedule as soon as possible. Child support is encouraged to be paid but not ordered by the standing order until the court makes a temporary order. You absolutely cannot move with the children while a divorce case is pending. For Collier County residents who are divorcing whether they have children or not, they must follow a series of rules to keep everything in the same status quo as of the date of filing until further order of court. The parties shall not conceal, hoard, or waste jointly owned funds whether, in the form of cash, bank accounts, or other highly liquid assets, except said funds can be spent on the necessities of life but only if the parties' regular incomes have been expended for such. If you've been served with divorce papers in Naples, Collier County, Florida, call my family law firm to schedule a free consultation with an experienced divorce lawyer.